Hello, everyone, and good afternoon from London. We are here at the webinar relating to human rights due diligence and investor engagement. My name is Iris Chu, and I'm a member of the UCL Centre for Ethics and Law. We are very pleased to be bringing you the webinar today. So I'm the academic advisor to the person who's curated this webinar, Laura Bletcher, our PhD candidate at UCL. Um, we are bringing you an evening of hopefully very interesting discussion on the role of investors in interrogating certain non-financial issues that are nevertheless material for investment portfolio management. And we have with us experts from practice, from the industry, as well as from academia. And without further ado, I'll hand over to Lara to introduce our distinguished panel.
Thanks very much, Iris. Welcome to everyone, and thank you very much for joining this webinar. As Iris said, my name is Laura Bletcher, and I'm a PhD student in law at UCL. And I've worked extensively with rights holders and investors to promote responsible business practices. So I'm really pleased this webinar is happening. I will set the scene for the panelist presentations, but first I want to thank UCL and the Center for Ethics and Law, especially Professors Iris Chu and Anna Donovan, for supporting this webinar. Thanks also to Kat Balogan from the events team for accommodating the webinar, what is a really busy year of events to celebrate UCL's 200th anniversary. So I'll explain who rights holders are and what human rights and environmental due diligence is, so that everyone is clear on the terminology the panelists will use. We often use the term stakeholders to mean various parties affected by an institution of some sort, and rights holders are a subset of stakeholders who are entitled to have their human rights respected, protected, and fulfilled by states. Technically, we're all rights holders in that we're all entitled to have our human rights respected, protected, and fulfilled. But the term rights holders, and specifically affected rights holders, generally refers to people who have had their human rights abused, violated, or threatened. A number of different parties can abuse, violate, or threaten people's human rights. States, non-state actors such as armed groups, and others. But today, we're talking about rights holders whose human rights are threatened or abused by businesses. And in this context, the UN Guiding Principles on Business and Human Rights, or the UNGPs, are the most authoritative standard globally and set out in their Pillar 1 how states should protect human rights from businesses. In Pillar 2, how businesses should respect human rights. And in Pillar 3, how both states and businesses should provide access to remedy for human rights abuses. More specifically, Pillar 2 sets out a process called human rights due diligence, which I will refer to as human rights and environmental due diligence, or HREDD, because the UN Working Group on Human Rights that oversees the implementation of the UNGPs has confirmed that the process covers environmental issues and climate change. So HREDD is a risk-based process that calls on businesses to identify, prevent, mitigate, and account for how they address their impacts on human rights. And this process includes engagement with rights holders, who the UNGPs and their interpretive guide largely refer to as affected stakeholders. But as HREDD is a voluntary process for businesses, and rights holder engagement is defined only in general terms, it's not clear how businesses should engage with rights holders to meet the UNGP HREDD standard. Institutional investors should carry out their own HREDD and should engage with investee companies to ensure that they carry out HREDD properly. But the UNGPs and their interpretive guide are even less clear about the role of rights holder engagement in investor HREDD. Yet the failure failure to carry out rights holder engagement as part of HREDD can have dire human rights and financial consequences for both companies and investors. If you're following the UK litigation against BHP and Vale for their roles in the collapse of a tailings dam in Brazil, you will recognize these consequences. As context, tailings dams collect mining waste and generally mix this waste with water so that it turns to sludge. And if dams of a certain construction collapse, the sludge can create a mudslide that destroys anything in its path. This is what happened in 2015 in Mariana, Brazil, where 19 people were killed on the day, and the mudslide caused what has been called the worst environmental disaster in Brazilian history. Appropriate stakeholder engagement could have mitigated, if not prevented, this collapse, as a dam inspector had identified cracks in the dam and informed the companies about the cracks prior to its collapse. Inappropriate rights holder engagement has exacerbated the damage to both human rights and the company's finances. The companies established a poor remedial process that, according to rights holders, did not respond to rights holders' needs and has not remediated the damage properly, let alone at a reasonable pace. Consequently, a group of over 600,000 rights holders has sued BHP and Vale in the UK for £36 billion, and that's on top of litigation worth additional amounts in Brazil. In November of last year, the UK court sided with the rights holders, although the companies are appealing the ruling and the amount of damages remains to be set. In any case, both investors and the companies would have been able to respect human rights significantly better and consequently could have saved a huge amount of money if BHP and Vale had engaged appropriately with rights holders and stakeholders more broadly. So our panelists will share their thoughts on how investors can engage appropriately with rights holders through their HREDD processes to help ensure that their investee companies respect human rights. Our first speaker, Professor Stephan Park from the University of Connecticut, will discuss the incentives and capacities of investors and rights holders to engage effectively. Our second speaker, Liz Umlas, Senior Advisor to Industrial Global Union, who engages extensively with investors and a particular subset of rights holders, workers, will talk about capital stewardship as a two-way street. And our final speaker, Dana Phillips of Morgan Stanley, will share how she undertakes HREDD, including when and how rights holder engagement fits into this process. These three presentations will be followed by a panel discussion and then questions from the audience. Please use the Q&A box in the chat to submit your questions. And without further ado, Professor Park, we are looking forward to your presentation.
Thank you, Laura. First off, I want to thank the UCL Centre for Ethics and Law for hosting this event, and Laura and Iris in particular for highlighting this important and timely topic. I've long been interested in the intersections of financial markets, human rights, and the transnational dimensions of business regulation and governance. And I think similar to corporations, the concept of HREDD enables us to explore how institutional investors can more effectively address environmental and social risks, but in a way that is distinct from companies due to their roles as intermediaries standing between companies and asset owners. So in order to advance this debate, I think we need to acknowledge that distinction and consider the range of legal and market-based tools available to address it. So I see the topic of this panel as a set of four questions. First, as suggested by Laura, what is meaningful stakeholder engagement? And how does it fit into the role of the institutional investor? And then I think a third question lies with, of course, the implications of HREDD for meaningful stakeholder engagement. And then finally, how can HREDD in practice improve stakeholder engagement? I'm not sure that I have adequate answers to these questions, and I definitely do not have enough time now. But what I want to underscore for further discussion, and in particular, with interest in hearing what Liz and Dana have to say, is that most institutional investors do not engage consistently in meaningful stakeholder engagement due to a lack of alignment between their legal duties and financial incentives and HREDD. So I would argue that our goal, if in fact we think that meaningful stakeholder engagement is important and should be an element of HREDD, is to figure out how to increase the capacity of institutional investors as well as their incentive to align these concepts. So first, regarding the concept of meaningful stakeholder engagement, as a lawyer, I would like to start by defining terms and concepts. And so broadly speaking, as we all know, stakeholder engagement in management theory and practice is a process of interaction and dialogue between a corporation and its stakeholders. So in theory, stakeholder engagement enables the company to learn about the interests and concerns of stakeholders and address those concerns. The term affected stakeholder, as Laura referenced, is embedded in the UNGPs and incorporated in the CS3D, captures the notion of a rights holder. It's also a term, importantly, as John Ruggie noted, familiar to companies subject to other legal requirements and industry expectations and standards. So the concept of meaningful stakeholder engagement that flows from this term affected stakeholder refers to ongoing stakeholder engagement with rights holders in order to enable the company to identify and mitigate salient human rights risks. And in the end, I think what makes stakeholder engagement meaningful is that it addresses the needs of all affected stakeholders based on a two-way communication that is proactive, responsive, and ongoing, as the OECD articulates. As researchers in business human rights have pointed out, stakeholder is a de facto requirement for complying with mandatory HREDD. So companies on the value chain may suffer a range of different kinds of legal, financial, reputational, the consequences if they don't effectively engage with stakeholders and fail to identify these salient human rights risks. But in practice, we know that stakeholder engagement often falls short, far short, as in the example that Laura referred to, of anything constituting a dialogue. And so this is where I think investors fit in. I think it's important to acknowledge that investors occupy a curious, maybe unique place in stakeholder engagement. So they are themselves stakeholders under this sort of broad term, and they're certainly affected parties in many instances. They also serve as representatives and duty bearers under the UNGPs. So as Laura noted, they can conduct meaningful stakeholder engagement themselves, or they can compel companies in their portfolios to do so. So why might investors conduct stakeholder engagement or compel companies to do so? So first, stakeholder engagement serves an informational function. It enables investors to gain insight into how the operations of companies and their portfolios affect workers, communities, and other stakeholders. So why does this matter? If you think about it, institutional investors, and I'm thinking principally of asset managers, have two functions. So they are responsible for making decisions regarding the allocation of capital by investing or divesting in a particular company's equity or debt. And so they devise and implement investment strategies and guidelines that can screen out or integrate various environmental and social factors. Stakeholder engagement, in theory, enables institutional investors to identify human rights impacts that they would otherwise miss, contextualize those impacts that may be material, and then improve the valuation of assets by more accurately accounting for environmental and social and human rights related risks. Now, to the institutional investor, these risks are manifold, and they may include financial risk of various sorts, reputational risk to the investor, enterprise level risk that is evident by a particular form of human rights risk, which they may learn from affected stakeholders, and then, of course, various kinds of legal risk, including disclosure obligations. Secondly, stakeholder engagement can be a part of an institutional investor's stewardship practices. So shareholder dialogues with management, proxy voting, and other forms of engagement are strengthened in theory when informed by affected stakeholders. And so the question is how institutional investors conduct stewardship in a manner that accords with meaningful stakeholder engagement. And typically, the way that large asset managers do so is to engage with corporate management on these issues. So let's step back for a minute. What's the problem as far as the role of institutional investors are concerned? So apart from various HREDD laws, many companies are already conducting some sort of HREDD on the downstream part of their value chain, right? That human rights impacts in the delivery and consumption and end use of a product or service. So for investors, the downstream part of their value chains include the human rights impacts of investee companies in their portfolios. However, according to various studies, including a 2023 report by the Danish Institute for Human Rights, financial institutions score very low on engaging in HREDD on their value chains, and in particular, meaningful stakeholder engagement with their own workers and with consumers and the communities in which they operate, let alone any sort of clients or investee companies. And so, like companies, financial institutions, including institutional investors, can employ different proxy approaches by consulting with civil society organizations and unions and various community representatives. But the evidence, by and large, suggests that uptake is very low and highly variable. Now, a question I've been grappling with, and for which I honestly don't have an answer today, is, well, why is that the case? I think you can first point towards the role of capacity, so that certain institutional investors may lack resources and expertise to engage in the mapping and scoping and development of a due diligence plan. But I also think there are questions about their leverage to change investee company conduct or remediate. And I would say that depending on the investor and the specific investment portfolio, that leverage is highly contingent and varies. So if you can look at the difference between investments in equity stock versus investments in various debt, such as bonds, the role of index funds and alternative assets, such as private credit, those all involve different kinds of relationships that these institutional investors may have with investee companies. And then, of course, you got different investees, right? So we predominantly end up talking about large publicly held corporations. But of course, there are other assets that are managed, including various debt and equity issued by sovereigns and state-owned enterprises. I think another issue in that vein that merits more attention in the business and human rights discourse is the heterogeneity of investors themselves. And so I think you see these clear distinctions in practice between engagement with stakeholders among SRIs, socially responsible investors, and then so-called mainstream institutional investors that primarily use environmental and social factors in integrating them alongside various financial objectives. So I think a third question is to consider the implications of HREDD in particular for meaningful stakeholder engagement. And so I'll just say very briefly that, as many attendees know, the EU ultimately decided to exclude financial institutions, investment managers, as well as banks and insurers and the like from the scope of the CS3D with respect to downstream impacts, including Article 13 requirements to carry out stakeholder engagement. And then the amendments to the CS3D approved in December also removed financial institutions from the Article 36 requirement, which would have required the Commission to produce a report on the environmental and social impacts of financial institutions. And I think what these measures signal to investors is that HREDD does not apply to them, right? And that they should engage with stakeholders, I would say primarily through their various stewardship functions rather than through direct or independent stakeholder engagement. Although I do wonder, and I frankly have not considered this question in any depth, whether the transposition of the CS3D by EU member states will add any nuance to investor obligations with respect to upstream HRDD, and whether that will have any spillover effects in practice on how investors and other financial institutions engage in downstream due diligence. So ultimately, I would say that investors still lack an understanding of how their fiduciary duties and their business models enable them to conduct stakeholder engagement. And so let me just very, very briefly, in the interest of time, highlight a few ways in which we can align those incentives, and certainly look forward to hearing from Liz and Dana in particular about how they've been able to do so. One is, I think, obviously highlighting the role of investors as not only stakeholders, but privileged stakeholders. Also, another one is to impose pressure through certain clients, in particular, sovereign wealth funds and pension funds, through investment objectives and side letters. I think a third factor has to highlight, of course, the financial materiality of human rights risks and to the point, the value of stakeholder engagement in identifying those financial risks. And I think various business and human rights organizations have sought to assist investors through knowledge and capacity building. And I want to highlight in particular the stakeholder engagement guide developed by Rights Collab in coordination with numerous organizations. And then lastly, in a similar vein, I think we can develop frameworks to show how HREDD and stakeholder engagement in particular can serve other purposes. So you can think of stakeholder engagement as a means to complement what, say, banks do with know your customer requirements. Consider the ways in which stakeholder engagement may complement, for example, various investor obligations under the SFDR, or in the UK, the sustainable disclosure requirements, in particular for sustainable products. And I also think it's important to highlight, and I suspect that investors and the various organizations that engage with investors on stakeholder engagement see the ways in which environmental and social due diligence under other standards and requirements complements and builds on what is envisioned under HREDD in particular. And so in that vein, I think of the Equator Principles and the UN Global Compact and various social and environmental disclosure standards such as the GRI. So I think in the end, what I would say is that notwithstanding the legal status of the various rules regarding HREDD and their application to institutional investors, I think that there's still room for significant innovation and growth, but it has to come from a place that recognizes where these particular actors are situated within the universe of business and human rights. Thank you.
Thanks very much, Stefan. That was super interesting. Liz, would you like to present now?
Yes. Thank you, Laura. So my name is Liz Umlas, and as Lara pointed out, I am a senior advisor to Industrial Global Union. We are a global union federation that represents over 50 million workers in 140 countries in the mining, manufacturing, and energy sectors. And I'm going to talk about something called capital stewardship, which is another term for when trade unions engage investors. And what I'm going to talk about is actually what can be a two-way street, borrowing from Stefan's term, a two-way street, in this case of investor and labor engagement. My work in capital stewardship goes back over a dozen years, so I'll be speaking from direct experience. So the first question, why do trade unions engage investors? And there are a couple of reasons. One is when there are serious human rights violations at individual companies, capital stewardship is a way in which we can try to address those. And secondly, we use capital stewardship to try to achieve broader goals related to workers' fundamental rights that may go beyond one company, may even go to an entire sector. And the large objective here is to change company behavior, to improve conditions for workers, whether it's at one company or beyond. And that might mean pulling up wages across a persistently low wage sector, increasing support for what are the enabling rights of freedom of association and collective bargaining. Where the two-way street comes in is that investors that engage trade unions for their part are often doing so for their own reasons. One might be as part of their investor due diligence on a particular company. It falls under what Lara and Stefan have talked about as meaningful engagement, which is expected of investors under the UNGPs and the OECD guidelines for multinational corporations. And this kind of due diligence can help them in their dialogue with companies by providing granular information that deepens their engagement work, that helps them to distinguish performance across companies. One of the things that the questions that we get when investors come to talk to us is they want to know the difference between one company and another or across a group of companies. It can also give them an opportunity to hear direct testimony from workers, and there isn't a real substitute for that kind of testimony. Secondly, investors may engage trade unions to better understand sector dynamics, systemic problems that can affect their portfolios, like an example which I'll bring up in a few minutes, the phenomenon whereby companies continue to pour money into factory self-monitoring or social auditing, which has been something that's been around for decades, in which multinationals hire commercial auditors to come in and inspect factories and farms and other facilities. And they continue to pour money into that model despite it being discredited, instead of into mechanisms that might provide more effective supply chain due diligence. So I'll come back to that example in a moment. And this two-way street then arguably helps both labor and responsible investors to attain the goal of more sustainable company behavior and addressing systemic issues. Taking the first type, where trade unions engage investors on individual companies, when do we do this? We'll do this when other channels with the company, such as collective bargaining, are blocked, for example, where we see patterns of violations at a company, where we see egregious violations at particular work sites. How is that engagement? What does it look like? It might consist of investor briefs that we provide to investors on a particular company or a particular set of issues. We hold roundtables in which we might have a small number of investors coming to talk interactively. We've held many webinars on worker rights related issues that we open to investors. We hold one-on-one meetings with investors, and we hold what we call pre-AGMs. They are as they sound. They are held on the eve of annual general meetings, where we invite investors in to hear from workers and to talk about issues that may be brought up the next day at the company's AGM. We collaborate with coalitions such as the Committee on Workers' Capital, which is a network of trade unions and asset owner board members, with the Labor Rights Investor Network, which is a global network that supports investors as an educational exchange platform. We work with coalitions that are more familiar to the UK market, such as Share Action and PERC. And we go to annual general meetings yearly, in which, again, we will bring workers to speak directly to other stakeholders, other shareholders, and to the board and executives. In terms of how effective this is, it's somewhat anecdotal. You might not be surprised to know that it is quite difficult to measure the impact of this kind of work. But we anecdotally have noted that companies have become more open to sitting down with trade unions after investors have gotten involved. And again, the two-way street, we see that it benefits investors because they gain knowledge that they might not otherwise be able to access. And this goes back to Stefan's point about incentives and access to information. In terms of challenges to this kind of engagement, again, hard to prove causality. There's a bit of a black box going on. And again, turning to one of Stefan's points about the heterogeneity of investors, at least for the first several years of this work that I was carrying out with global labor unions, it was often the same group of investors. It was self-defined, responsible investors. I would say that has arguably started to expand in recent years in an encouraging way. So I think that there's a bit of a light at the end of the tunnel there. The second type of engagement has to do with engaging on broader goals related to workers' fundamental rights beyond one company. When do we do this? When we're facing sectoral or systemic problems. The how is maybe best demonstrated by giving you a specific example. So coming back to the social auditing example that I flagged a couple of minutes ago, Industrial has been working to turn the ship away from what we think and what research has pointed out is a failed model, and that is social auditing, in which you have a commercial relationship between a multinational and an auditor to inspect a factory, give it a green light, and allow the work to go on. That is a model that over several decades actually has gained more and more criticism. And so we've been working with other unions as well to turn the ship away from that model and towards a model that promises change. And that is specifically binding agreements between multinational corporations on the one hand and workers or trade unions on the other. And these are legally binding agreements with market consequences for non-compliance, with workers and trade unions built into the governing structures. They generally have effective grievance mechanisms, are based on transparent reporting. The International Accord on Health and Safety in the Garment and Textile Industry is perhaps the best known example that some in the audience will have heard of. And notably, these binding agreements are built on addressing problems beyond one company. Our objective as Industrial is to move the needle on a large group of companies or even a whole sector to improve, for example, working conditions or wages. And so in 2024, 2025, we worked with the Labor Rights Investor Network, and we together worked with an investor working group that consisted of about 15 institutional investors from North America and from Western Europe that together produced a guidance document on binding agreements that all investors can now use. It's a public resource, and it compares binding agreements to social auditing. It pulls together some of the vast literature, which has been around since the 1990s on this issue. It provides an investor case, and it also provides possible comeback answers for investors to give to company responses on supply chain due diligence. So it can improve investors' engagement and readiness. And in the process, we worked with investors to bring them up to speed on binding agreements and why they're more robust than social auditing in both human rights and risk mitigation terms. And some of those reasons are they offer systemic solutions. They tend to have broad buy-in from companies and workers, and they are arguably more cost-effective than each individual company hiring their own auditor. Again, I come back to the two-way street. Investors are becoming more and more focused on system-level risk and how it affects their portfolios and what the root causes of these risks are, and how to address the problem of being a universal owner, paying the price for systemic and market failures such as climate change and income inequality that's exacerbated by very low wages. And we would argue that it's in investors' interests to work towards addressing these issues that are harmful to human rights, harmful to society, and therefore harmful to long-term investment prospects. And that might go a little bit of the way towards Stefan's question about aligning incentives. Also, this kind of engagement provides investors a real opportunity to be part of a positive change in which any single actor, any single asset manager, no matter how big, any single pension fund, trade union, or multinational cannot bring about change on their own. In terms of how effective this kind of work is on the sectoral level, with the binding agreement guidance, it's early to tell because it was published just last year, but investors are using it, they're citing it, and we see a high level of interest. Challenge is that we need a critical mass of investors paying attention to systemic issues to move the needle. I would close by saying that overall, we're finding that investors are more proactively approaching us than in the past. And interestingly, they seem to be more receptive to our outreach, including on freedom of association, and not only on child labor and health and safety, which is kind of the narrow area that they were interested in even a few years ago. The big caveat, the elephant in the room, which I'm sure we're all going to talk about, is, and Stefan pointed to this in his remarks, the current political environment, the pushback against ESG, which is strongest in the US, but has also come over to Europe as well, and may have led some asset managers to pull their punches. And it's certainly made it harder for trade unions and civil society organizations to engage investors, though there are exceptions to that. And just in closing, I would say, arguably, investor engagement of stakeholders is even more important in this kind of climate, where laws are being rolled back. Stefan referred to the CSDDD, where that's happening. Investors still need the information, and they have said to us, regardless of what happens to the laws, they're going to keep coming for this information. And I'm not saying that voluntary engagement replaces laws and regulations, which we absolutely need, but we work with the tools at hand. And I would say that investor engagement remains a crucial tool. Maybe with that, I'll hand it back to you, Lara, or to Iris.
Thanks very much, Liz, and thanks for flagging some positives there in the current environment. Dana, would you like to present now?
Yeah, I think that's a perfect place for me to start. And apologies, I have a cold with my 2 young children, but I am a member of the Global Emerging Markets Equity team at Morgan Stanley Investment Management. I need to start out by saying these thoughts are my own. They don't represent all the thoughts of Morgan Stanley as a whole or the thoughts of Morgan Stanley Investment Management as a whole. These are my own. And I'll start by saying, kind of agreeing with Stefan about why we do it and what's important about doing human rights due diligence, and then how we do it and how that's changing, which goes directly to Liz's comments as well. The reasons why, so we are investment managers, again, in the equity space. So as Stefan said about leverage and equity, that's how we're coming at it as well. To meet client goals and directives, we emphasize this active stewardship. We do it through direct company engagements, proxy voting, both essential components of our process in different ways for different funds that have different directives and objectives. We have several methods by which we engage: Zoom, in-person, on-site visits, collaborations, and we also vote our proxies, as is our fiduciary duty, and all of our thoughts when we vote our proxies are included in that. And in fact, we have multiple team members reviewing each proxy, trying to take a global perspective from that. When we conduct engagements, we conduct them alongside senior management meetings, usually with different people. Sometimes senior management is in the room. We evaluate financial health in our senior management meetings, strategic direction, growth. And then in our engagements, which are more non-financial in nature, we evaluate all of the other things, right? So that includes very much so human rights due diligence, environmental due diligence. We prioritize these conversations because we want to learn about culture. We want to learn about how they're managing their labor, supply chain, governance, for all the same reasons that Stefan highlighted, including reputational, enterprise level risk, legal risk. What are the financially material things that we need to consider when we're investing in this company? And while these aspects are often qualitative, so not quantitative in nature, we do integrate them through a lens of financial materiality, and we think it helps us to spot long-term value creation or destruction potentially of a company. And especially in emerging markets where public disclosure is often limited. You heard both Liz and Stefan talk about how resource intensive it can be to prioritize engagements, especially with stakeholders, not just with companies, but with community members and different levels of stakeholders, both community members and employees and workers in the whole supply chain. When you talk about tier 1, tier 2, tier 3, tier 4, how that's communicated, how the social auditing is completed. Public disclosure is often relatively limited, or maybe a little bit more check the box, where you might see even the best companies disclosing like, hey, yes, we socially audited that, and all there is a tick, right? So it is very important for an investor like us to understand what and get more transparency. And here you can typically hear from a company and get a pretty good gauge in an engagement, even over Zoom, whether it's like a check the box activity or whether they actually have done the work, have engaged. But even in those cases, it's helpful for us to augment, especially in particular industries. And I think Liz covered some of them, but think, your mining industries, even going into technology these days, engaging with community members, engaging and hearing from NGOs and trade unions and the like to help us understand what is the other side of the story and is what we're hearing helpful and true, right? It helps us get the entire picture, especially when it can be material to the strategy, as I said, in places like mining can stop production, or we just know there are systemic sectoral issues. So for an example of that would be hearing from community members potentially about like emergency planning with the company if they're in the mining industry, and whether or not there is posted signage, whether or not that posted signage is working, have they practiced it? That helps us get a full picture of it without actually having to put boots on the ground where we might not have access, or it helps us hear if what the company is telling us or is what is publicly disclosed is actually what is heard by that story, by that community member. And so I agree with Liz completely. There is no substitute for that kind of testimony. And we have done it on occasion. It's been very impactful to us in multiple ways. We do rely on NGOs to bring us these stories. Again, as equity investors, it's very hard to get that information. We used to have to dig very deep, go like kind of to the ends of the web and look for that information. Or again, it would require a lot of capacity from one of our team members to go and engage with these NGOs and trade unions. But AI is really changing that story and really helping us to fill that information gap. For example, AI can scrape the web. I actually did it yesterday just as a test, but can scrape the web way better than we humans can and look for particular information that is prompted to do so. So, have there been public comments at AGMs? Have they been named by any of the NGOs or trade unions? We can give AI a list of the ones that we're looking for, and it becomes much more less resource intensive to us to have this information at our fingertips, especially if, and we are so thankful to these NGOs and trade unions for doing that work for us. Like it's somewhere out there on the web. It might be in a very far away report, right? Like I've looked at some of Industrial's reports and London Mining Network. I've looked at Safe in India Foundation for some auto information, and it AI just really opens the door for us. And what we've done with that information is we use it in our engagements with companies, right? So we can show them how easily it is for us to get this information, and either they should disclose and give us their side of the narrative, right? Or make a public comment about their own actions. And that allows investors to really have much bigger picture when they're investing. It both pushes for momentum and disclosure, but it really allows investors to conduct more the more due diligence they have and whether or not they want to invest, and let the market make the decision as to whether or not that's financially material. And so that is really what our process, why it's important, how it's changing, where we see our role is to continue to do that. We do understand the political environment. We don't, I don't, from a necessarily political perspective, think about that necessarily when engaging. We want to just understand what we're investing in and conduct due diligence and be able to understand what the full picture is and what the risks may or may not be out there, and be able to make the decision for ourselves. So those are my comments. Thanks very much for joining and for the webinar on this topic. I have to say it's a really important topic and not one that's well discussed, especially in the community and with the political environment the way it is.
Thanks so much, Dana. It's hugely helpful to understand what an actual investor does in relation to human rights and environmental due diligence and stakeholder engagement. Iris, am I handing over to you now?
Right. I mean, I think the panelists are really interested in each other's comments and each other's experience. And at this point, we would like to strongly encourage the audience to submit to us any questions that they might want to direct to any of the panelists through the Q&A function. But pending that, I think it might be useful to have an inter-panel discussion, especially where we might have many questions ourselves for each other. And if you wouldn't mind, I would like to start with the first one. And I mean, my research expertise is in financial regulation, and I mean, from my vantage point, I'm just wondering what is the appetite really for kind of law and law reform in relation to the investor's role? I mean, at the moment, in jurisdictions like the UK, EU, and many other jurisdictions, and even stock exchanges have taken the lead to have stewardship codes where they encourage, investors, institutional investors, to do various things in relation to the engagement with investee companies and to protect their own interests. Many of these are framed around really the needs to ensure that investors can manage the financial risks that are material to their portfolio management. But these are all soft law. And I guess the EU Shareholder Rights Directive has gone that little bit further in nudging these codes to come into existence and these best practices to be undertaken. In terms of harder law, the anti-greenwashing laws for sustainably labeled funds, such as the UK, might have some effect, as Stefan has mentioned, in relation to funds that are labeled as trying to establish sustainability impact. Then there is more required on the part of asset managers to show what they have done. And undertaking these forms of due diligence might be one way in relation to how they deliver that sustainability impact label for the fund. But other than that, I'm wondering whether there is an appetite and what would be the justifying rationale for investors' actions, investors' engagement to be placed on a stronger footing in terms of law. Would there be such an appetite, and why? And if not, why? And I guess this is probably open to all the panelists. Would you like to go first, Stefan?
I'm rather skeptical, to be honest, that there is enough of an impetus for sort of a industry-wide mandate for sort of investor-based or driven stakeholder engagement. I do think, as I suggested in my remarks, that more can be done to incentivize institutional investors and other financial institutions to identify the ways in which stakeholder engagement enables them to comply with other legal requirements, including those imposed by their clients, right, through investment objectives and the like. And I think, Dana's and Liz's remarks suggest that, in fact, financial institutions will find those incentives, right? They have a clear sort of economic and financial and reputational rationale to determine all the different ways in which they can deliver what is expected of them. And so I think I think it's tempting to rely on sort of the information forcing role of stakeholder engagement as a means to sort of drive more meaningful engagement. But I think, at least in the short term, that's what we really should be looking at.
And I would just add that I think from an investor perspective, you would really need, we're doing what our asset owners and what our clients wish, and you would really need the asset owners to wish for that. And I think that it just depends. From our perspective, obviously, we feel that there are certain pieces of both human rights due diligence and environmental due diligence that completely rounds out the picture. Obviously, governance due diligence as well. That helps us understand the financial picture. And we come at it from a lens of financial materiality. But I think also, reputational risk, legal risk, enterprise level risk. Those are all very important risks to understand as well. And depending on the sector, can be financially material. But we really rely on what the objective of the fund is and the objective of the client is. And we go back to that quite often. And we do have clients that want that. And we have clients that don't necessarily push for that. So it's really about the objective of the fund. And now, when we engage in the stewardship overarchingly, that's just for our own information and for the due diligence. But in terms of going really deeply and understanding, there can be that piece, especially from an environmental perspective. We have seen where clients have certain environmental objectives in their portfolios, and that leads us to need to understand how the environmental piece might play out over a longer term, right? So if a client has a net zero target, you're going to need to understand what the net zero targets are in each one of your portfolio companies and how that rolls up, and that becomes a portfolio construction exercise to either meet that target or understand what their decarbonization plans are. And I think the same can be true of human rights due diligence, but we haven't seen that level of like targets met yet and really coming down to that sort of pushing. But from an engagement perspective, it's kind of one and all the same rolled up in due diligence.
Thank you, Stefan and Dana. Sorry, Lara, would you like to go?
Sure. I just wanted to check if Liz wanted to go first.
Well, I think in addition to laws or short of laws, there are other incentives, and there's research showing, for example, trade union presence being associated with lower health and safety problems in the workplace and lower pay discrimination across various categories. And I think just now Dana was mentioning the long-term lens. The sectoral risks that I was talking about in my comments aren't necessarily captured, I think, by what's going on in laws and legal reform right now. But I believe that investors are starting to understand that on their own. They're starting to understand the longer term risks of climate change, the very big risks associated with inequality, which then play out in political instability. And so I don't know that, I mean, obviously the laws, I think would have moved us along, but I think that we're also some of these other incentives are pushing the debate forward as well.
Okay, thanks. I just wanted to make one point, which is something that's come up in my PhD research, is that some of the new lawmaking on human rights and environmental due diligence, such as the CSDDD, tends to import the voluntary soft law models that have been used over many decades now. And the consequence is that the way it's being imported allows businesses to continue to employ human rights and environmental due diligence in a voluntary and discretionary manner. So if there are going to be laws in this area, I think we need to be very careful not to reinforce models that allow incentives for businesses and investors to use too much discretion in how they implement human rights and environmental rights. That they need to align with international human rights and environmental law more than they have been in the recent incarnations. Thanks.
Thank you, Lara. And I think that follows on nicely to a question that's been submitted by one of the members of our audience. So, Seshlin Call. Sorry if I've mispronounced your name, but I found your question to be really, really interesting. The question is, to what extent do you think mandatory human rights due diligence laws will change seriously how companies and investors engage with stakeholders? And I would just like to add a bit of a comment to this question because as Lara has mentioned, I mean, the issue with mandatory law is that if mandatory law leaves a lot of discretion to the private sector to implement, then you might have a problem with actually meeting the expectations of stakeholders, whether the standards are there to meet the expectations of stakeholders. But if you have mandatory laws that are tighter in terms of how they control implementation, then there is the issue of whether or not they are appropriate and whether they will be outpaced or outdated, or are they too prescriptive. And one of the issues is cost, as well, where investors are concerned. If you impose cost on investment funds or asset managers, then that gets passed on to your investors, and there is that conflicting goal between preserving value for your end investor as well as being able to play an influential role in hopefully bringing about a better economic society. So I think this question brings about a large scope in relation to what is actually mandatory human rights due diligence and what does it serve to do, and then what would it do if it were implemented. I guess over to our panelists. Anyone in particular who would like to take this first? Oh,
I
Lara,
guess I
yes.
I can just build on my prior response. I'm a bit skeptical about the current approach of mandatory human rights and environmental due diligence for the reasons I mentioned. And if you look at the stakeholder engagement provisions in the laws, again, they're not very strong. For example, they don't refer to free, prior, and informed consent in relation to Indigenous people, and they're quite general in a similar way to the way that the UNGPs are. So, as you say, Iris, it leaves quite a lot of discretion about when and how to engage. And I haven't seen anything that makes me think it will compel stakeholder engagement in a way that meets, for example, international human rights law standards.
But I would just add that I mean, outside of regulation, what I have seen as a meaningful change is the asset owner community and the newer generation of investors asking for this information. And that really does change. I've I have witnessed that changing the mindset and also the availability of information out there, like with AI, but the ability that asset owners and those, actually doing the investing and driving the objectives of funds should not be overstated in terms of being able to change an investor's mind and change a portfolio manager's mind. If the investor wants it, the asset manager wants it, it's going to get done, right? If they want a rationale for why XYZ company is, is on a watch list by, MSCI for, and this happens for like OECD violations or ILO violations, or from any of the third party, they will get it, right? So I do think that there is a lot of, and I also am a little bit skeptical of, I think regulations help the sustainability community quite a bit and can be a really good tailwind for us, especially in terms of disclosure. But when they're really overarching, it does, and especially when CSDDD first came out, in every engagement I was in, especially in Europe, a company would say, well, I'm just working on 1,300 different indicators for tick the box exercise. And that seemed really, to be honest, that seemed really distracting and kind of unnecessary. And I would typically say, okay, but which one is, we just want the three most important. And I know that that makes it hard when each investor is asking for X, Y, and Z. And it's so all encompassing that no one can focus and they're all just trying to tick the box. That's what we don't want. But again, I think the asset owner community has a really strong ability, and that's where, up and coming students who are then joining the workforce, they all have that ability to push that change forward if those are on their minds in terms of objectives and how they want to invest.
Thank you, Dana. I think Liz had your hand up. Would you like to go?
Yeah, sure. Those are really, really good insights, Dana. And we too have seen asset owners pushing the envelope. I think that's one hopeful area, and I would totally agree. And related to that, I think we should not underestimate the impact of, to use a political science term, the demo effect of a core of investors who are taking up meaningful engagement and taking up serious due diligence and finding that it helps them to reduce risk in their portfolio. I don't know that laws are going to necessarily, we need them and they have to keep up with the change. But as I say, investors are already seeing those changes. And there are jurisdictions like the United States, which are going backwards, like passing laws that tie the hands of pension funds. And they're speaking out and saying, we actually need the ability to invest in such a way that our portfolio is not going to literally be underwater. And so they're going to go and do the engagement that they have to do because they understand that problem. And that demo effect may be, I hope that it will be taken up, as Dana says, by another generation of investors and by asset owners who do seem to be stepping up to the plate. I think it's a very powerful concept.
Could I add something?
Yep, please go
So,
on.
so further to what Liz referred to as the demo effect, I think you can look at mandatory HREDD laws like the CS3D as serving as a template for different ways in which industries might, as Liz suggests, decide on their own terms to conduct stakeholder engagement. And I think we're now at a point where there's such a divergence across different capital markets and other jurisdictions where that is going to be evident. And so I think that is ripe for further study. The other way in which I think mandatory HREDD matters is in terms of the remedies. And so there's been a robust debate in the context of these national HREDD laws about different liability mechanisms and administrative remedies and rights of action. And since the CS3D and its current form post-omnibus doesn't have an EU-wide civil liability regime, we're probably going to see, I imagine, different approaches by different EU member states and then other jurisdictions to this question of what are the consequences for not complying. And so I think that will provide further evidence about sort of the role of sort of ongoing monitoring by the regulator, and then for which I think other interested parties will take their cues. And then the other point I want to highlight in response to the question is the ways in which sort of different aspects of these, or I should say, the ways in which different topical objectives of these laws may incentivize or motivate or compel stakeholder engagement. So, for example, there are certain risks that are more salient to rights holders, but also more material to investors, right? So Liz has referred to the concept of climate change and universal ownership. And so you can think about the ways in which the referenced standards in the CS3D, for example, may highlight certain kinds of risks for which there will be more motivation to engage in that stakeholder engagement. And again, I think that's ripe for further research.
Thank you, Stefan. I would like to urge members of the audience to send in your questions if you have any. for our panelists. I mean, we've had only one so far, and our panelists are quite keen in seeing what questions you might have and be able to address them. Um, I mean, I think my personal point of view is that in terms of what Stefan has said, in relation to remedies for rights holders, I would see that in the realm of kind of corporate regulation, and I see CSDDD as an example of that. Um, and I mean, I do certainly appreciate the points made about investors having their own incentives and some rather strong incentives and being able to move the needle to a certain extent. There is a certain long-termism in this approach as well, in terms of the learning of information and then the translating into what this means and what actions to take. And sometimes I think rights holders may see that process as being too protracted, to meet their immediate needs. And there might be that scope for complementary and more direct forms of corporate regulation in relation to conduct and behavior and in relation to the provision of remedies and the kind of fragmentation of civil remedies across different national courts. That might still be an issue that requires some thinking about and is difficult to address, I think, without some sort of international coordination at that level. Um, I don't
If it's
see
if it's
any.
okay, I have
Oh,
a
oh
question
yes,
for
please.
Liz.
Yeah.
Since there's no questions in the chat, I was really interested in your thoughts on this binding agreements versus social auditing. And I don't know if there's any practitioners on like myself or if this is interesting to anyone else, maybe, but I would love to I mean, we engage quite a lot. Personally do about 40 to 50 a year and would love to hear, best practices in terms of the what you referred to as binding agreements, either is that between the multinational and the community or in the labor rights side, and why it's I think you referred to this a little bit, but like why it's so much better than social auditing, because you're right that social auditing is can be really, really nuanced. And I find that quite often. And especially when you dig deeper into it, there are so many different ways of doing it. And we've looked into several of them, like the IRMA way or the RBA way, and how the RBA way is changing and going more towards the IRMA way. And then there's all these independent auditors, and it can get really confusing. And I think from an investor perspective, we look for whether or not they're social auditing, but and I've dug pretty deep into this, but would love to hear. This binding agreement thing is a little bit of a more nuanced topic that I'd love to hear more about.
Sure. Thanks for the question. So first, let me start out by saying that IRMA is in a different category than what I was talking about. The binding agreements that I'm talking about have been mostly in garment and textile, and they are a reaction to the commercial auditing that has prevailed for the past several decades. IRMA is a gold standard as far as industrial
Yes.
I mean, literally, but I mean, it's a really high integrity standard that has had a true multi-stakeholder collaboration. So Industrial has been involved on the labor side, NGOs have been involved, community organizations, companies. So that, I think I would put that in a category where that particular auditing standard has been very, very well thought out and put together very carefully over the years. So that's not the kind of thing that I'm criticizing. What we are criticizing is the commercial auditing that has been around since the 1990s, that was a reaction to lack of due diligence in supply chains, where you had egregious violations of supply chain worker rights. And the binding agreements have risen up over the years. We've seen them, they're mostly in garment and textile, so mostly the International Accord. There's a new one called the Central Java Agreement. There's the Dindigul Agreement. There's the Lesotho agreements. In the food and agriculture, you have the Fair Food Program. In the shipping industry, you have the International Bargaining Forum. So there's a couple in other industries, but the guidance that we worked on with investors is focused mostly on garment and textile, because that's where the most experience has been around factory audits that have failed over the years. And so this has been a reaction to that. The arguments for it go back to some of the aspects I was touching on. So binding agreements are binding. They are legally binding. They are backed often by binding arbitration. They have market consequences at the end of the day, whereas commercial audits do not. They have very strong governance and independence aspects. They have grievance and remedy aspects, monitoring, reporting, and transparency. And if anyone's interested, I don't know if there are resources sent around afterwards, links, but I can certainly put the link to it's a public document. It's on the CWC's website. We can share that with everybody. And the point there is that binding agreements offer a really solid floor that social audits do not, because those have been commercial agreements between a multinational and an auditor, often kind of shrouded in opaqueness, and there's a fundamental conflict of interest where you're paying an auditor to monitor a factory site that you're paying them to do the audit, and they want to have repeat business, so they're going to give you the green light. Binding agreements are set up in a completely different way. They do involve inspections, so just to be upfront, IRMA involves inspections, binding agreements involve inspections, social audits do. So we're not saying no inspections, but it's how they are created and who's at the table and what the governance mechanisms are and what the kind of sharp-edged consequences are, since they are they're entered into by voluntary parties, but then they're binding on the parties. That's the hard-edged side that kind of parallels what we've been talking about laws. I don't want to take up more time on that, but that's a short answer.
Yeah, would love. I mean, yeah, and I'll follow up with you about this, but I would love to hear your thoughts on the tech side and RBA, because I think we have done some pretty deep work there and still don't really have a good feeling about it. And I know RBA has a new relationship with IRMA, and I was very through the oh my gosh, I'm sorry, the acronyms in sustainability sometimes kill me, but through the responsible something, but very interested to hear and go deeper with you in that topic. I think we could talk about it for years, and it does come down to that, because I think a lot of the disclosure, and especially for investors, and this is why hearing from rights holders, NGOs, trade unions, like if investors are not doing that check with all that's available to them in AI, like that's kind of on them at this perspective, because it's really easy to ask AI for any company, right? Are there controversies out there related to this? How are they auditing? How deep is the audited go? What kind of standards are they using? I think where it gets confusing for investors, including myself, is and I do recognize that IRMA is the gold standard, and I've done a lot of work on that. But what are the different standards? What are the best standards? Obviously, garment industry, but then there's other industries where it gets a little more. It gets definitely a little bit more where it's hard to understand whether or not that's a true social check. And there were parts of where we thought, oh, RBA is such a great standard. And then you look at it and you think, well, isn't it? Like, and then you have to look deep into the questionnaire, and that requires a lot of resources, right? So trying to get to the bottom of that is helpful as well.
That was one advantage of talking about investor engagement, of working with an investor working group. Like, what were the demands that they had around binding agreements? What did they want to know? What would help them most in their engagement of companies? And that was why it was a kind of breakthrough MO, if you will, to do it that way. It worked out quite well.
Yeah, and I think that's the benefit of collaborations in general. And one of the is still doing collaborations in these days is actually learning from other investors, learning from trade unions, learning from NGOs, and being able to put that into practice and help raise the standards across the board. I do think investors can help with that and help push for asset owners can help with that too. But investors provide that feedback that this is the standard we're being told is the gold standard or it isn't. We really need outside third parties, trade unions, NGOs to help us push for that standard to be improved, because we still need to rely on a standard, just from a resource perspective. And those rights holders, to get back to rights holders and stakeholders and community members and labor, and employees and workers, though their inputs really help us to cross compare that, and to know whether or not the audit was done well, whether or not it's, and I know it comes down to who's in the room when the interview takes place and all of that. So it's really helpful for us to have that input as an augment to what we're already doing in terms of due diligence.
Thank you both Dana and Liz. I have a follow-up question from Satchlin, and I think this one is possibly directed at Dana in terms of what responsible investor ownership actually means. So her question is that if an investor identifies serious human rights risks through stakeholder engagement, then what would be the next course of action? Would there be divestment? And if divestment is worse, and I would probably think she means worse for both the investor as well as for the stakeholders. What does responsible ownership actually require? So, from your point of view, what do you think? In your perspective as an investor, you might do.
Yeah, I think that comes down to, like, I think she's asking about escalation tactics. And from our perspective, like, divestment is kind of the last one because it does reduce your ability to do anything. When we think about escalation, that's sort of how I started the conversation, which is our different ways, methods of how we engage. We can engage Zoom, we can move to in person if we needed. We can do a site visit, and had examples of when a site visit changes my mind, either positively or negatively. We can ask and bring it to senior management. We can do letters on the back of that. And I would say, I think a lot of companies do react really well to letters, depending on how it's written, what wording is used, the tactic that's used in the letter, who the letter is sent to, how it is sent, meaning who's copied, how it's directed, how much, assets or firepowers behind the letter, what it says, if it gives actual recommendations. And then you just kind of keep the pressure on and continue to meet with management. And you can meet with higher levels of management. You can also engage with, we've had this happen where we were offered an engagement with an audit committee chair or a board chair. And those can have really positive outcomes as well. The other ways is to join a collaboration. When it's hard, you can join a collaboration. There are several collaborations out there, like the UNPRI Advance was very helpful in that. I was a lead on a UNPRI Advance, which is out in the ether for a long time while we owned a security, and that really opened doors to being able, because you have a lot of different firepower in the room, and it helps to be able to really engage with the true decision makers and see if there's accountability. You can push for accountability on a certain issue. So instead of saying, you did this wrong, you're really trying to push for, where does the board hear about this? When they hear about it, what, how many times is it presented to them? Who on the board is it presented to? And is it included in incentive schemes? That's one of the reasons we review governance, is because you want to understand what management is incentivized towards. There's collaborations, and then there's also proxy, right? Which is another way. And again, Stefan talked about this a little bit in terms of leverage, right? We're equity investors, so we only have certain types of leverage, but we do have, there's AGMs, we do have proxy vote. That is changing in some places as well. Like, there are some new rules in places like Korea. There's a lot of value up programs in Asia that are changing how influential proxy can be in a positive way, which is very helpful. And proxies are a way of making sure we voice our opinions on certain members and whether or not they're hearing us or engaging with us as well. And we think that's a really important piece of the puzzle. So obviously, escalation, divestment is there for us, and it does happen on occasion, especially when either it really might affect the financial situation or we have learned that we can't trust management. That's a really important piece for us. And if it does change our view of management, like, we that could happen. But we have a lot of tactics in the middle that we can use.
Thank you, Dana. I don't see any more questions come in, but I'd just like to give a final opportunity for panelists to ask each other if there is anything on your minds that you would like to bring to this conversation. Or Lara?
Thanks. I just wanted to ask everyone, and I think this speaks a little bit to Stefan's discussion of incentives. How do you avoid having a situation where investors just pump rights holders for information without, to Liz's point, having a two-way conversation, two-way street? And sort of making sure that there's a demonstration that the engagement is actually leading to better human rights outcomes.
I'll just say that's a heck of a question to close this panel. I'll just say very briefly that I think this demonstrates the importance of the concept of HREDD and the continued relevance of various means to provide sort of legal stability, consistency, right? So in order to understand what constitutes a dialogue and two-way communication, we need to have sort of a set of practices that are readily understood and that can be contested by stakeholders themselves, right? And then, of course, a process by which they can contest it. And I think that the purpose of HREDD is to again provide that sort of structure through which we can gauge what constitutes a dialogue. Because you're absolutely right that if we sort of resort to a kind of tick the box ritualistic notion of stakeholder engagement, it by no means, if it's left to the control of a company, will result in a dialogue on a consistent basis. And so I think there needs to be this process in place, which I think is maybe not a first order effect of HREDD, but certainly would be a second order effect to provide a sense of what in fact that dialogue constitutes, and then to bring to bear all the other ways and motivations for companies to engage in stakeholder engagement, which go far beyond HREDD.
I think Liz had her hand up.
Yeah, so I would say that it goes to maybe the question of building relationships between investors and stakeholders, and that's not always a natural route, I think. But for certain investors, we've been talking with them over the years. It's not a one-off, and I think that's one way to kind of avoid the extractive nature that Lara referred to, which I think is a really important point. There's some great initiatives and platforms out there that bring investors together. A couple of people have brought up collaboration, and that kind of distributes the work and brings investors in contact with stakeholders on a more permanent basis. And I think we should be thinking about that sort of model as well.
Thank you, Liz. Just wondering if Dana has
if I could,
Yeah.
I would just add, in the times that we've engaged directly with community members, it's been important for us to say two things, which is one is you want to be careful about what you then say to the company so that you're not directly attributing it to a certain person. It can't, there's a lot of like very sensitive information that can be shared when you hear from a rights holder, and it can be very impactful. In the few times that I've done it directly, it has impacted me and was very emotional. And so it took a lot of practice and thoughts on how to best then think about what you bring back to the company in terms of action items and engagement to make it both actionable, productive, and like bring it back to the like what right like that what I mentioned about accountability and all of that. And also I think it's important to mention, and we when I've done it with the community members, we have specifically said, like, we want to be clear that we're not promising you that we can fix anything, because that's important to note that, we, again, what our leverage is and what our position is and how we are able to, and what we are able to do about some of those situations and depending on the situation. So, again, it's a really helpful input, and it has to be handled with a lot of sensitivity around what the issue is. And because once you hear the story, it's kind of hard to get it out of your, sometimes it can be really hard to get it out of your head. And so handling that with sensitivity, and also making sure that expectations are clear. And that there is some level of follow-up, right? In terms of saying, okay, we can tell you this is what we brought to the company, or this is what we didn't, sort of trying to summarize back through. And I will also say that's where NGOs and trade unions can be really helpful, because they can help us in that piece of integral piece of making sure that they feel that their rights are also respected in even telling their story.
Thank you, Dana. I guess we are at about the time to close our panel. I'm just wondering if Lara wants to put in a final word, because you have put this panel and the academic vision for this together, and the center owes it to you for having brought this to us and to bring this very interesting conversation to everyone through this webinar. So if Lara would like to close, please.
Oh, thanks very much, Iris. I just wanted to close by thanking you and Anna and the center, and Liz and Dana and Stefan for agreeing to speak on what is, for me, a really important topic. And it's been frustrating over the years at times to get investors to engage. So it's, heartening for me to hear what Dana has said and what Liz has said about some of the positive developments in this space, to hear Stefan's framing of how to align incentives and capacities to promote this further in future. So yeah, I mean, I tend to be quite a cynical person, but I'm taking quite a few positives from the discussion, and I'm very grateful to everyone for having made that contribution. So thank you. And thanks to the audience also for participating.
Thank you all. So I would declare our panel closed and our proceedings finished for tonight. And thank you all for staying with us till the end.
Thank you.
Thank you.